Well, the New Nation movement says the signing of the Electoral Amendment Bill into law by President Cyril Ramaphosa means that the president has chosen not to give substantive effect to the Constitutional Court judgment that was handed down in June 2020. The organisation says on the surface the amendments effected by Parliament and now endorsed by the president appear to address the unconstitutional elements of the Electoral Act 73 of 1998 as far as it makes it possible for independent candidates to contest the elections to the National Assembly and provincial legislatures. However, the Amendment Electoral Act of 2022 carries some deep and concerning contradictions. We now speak to Matshepiso Finca, the spokesperson of the New Nation movement, which successfully challenged the country's Electoral Act in the Constitutional Court back in 2020. Also joining us is a Policy Analyst and Chairperson of Election Monitoring Network, Nkosikhulule Nyembezi, and both of them join us virtually. Great to have you. Thank you very, very much for joining us.
Thank you so much for having us here.
All right. Matshepiso, let me begin with you. What is the New Nation movement's reaction to the signing of the electoral bill into law?
Well, good morning once again. Good morning to the listeners. I think even in your opening statement citing our response, we really expressed our deep disappointment that the president has chosen to endorse and to ratify the work that Parliament shoddily, if I may say, produced after 33 months after the Constitutional Court judgment was handed down all the way back in June 2020. As you yourself said, not just us, but several civil society organizations, specialists in the field, even authorities who have been part of researching and studying alternatives to our current and unconstitutional electoral system, have expressed grave concern with what Parliament produced and pointed out very specifically the many loopholes and contradictions which really turn even the notion of one man, one vote for one, and even the essence of democracy really turns it on its head. So even with those concerns and those serious concerns having been raised, the president decided to assent to this bill, promulgating it into law, and forcing us, obviously, then to return to court, to call on the Constitutional Court in the matter.
Okay, I'm going to quiz you on that as well. But first, Chair, let me come to you. What do you make of the concerns that have been raised by the New Nation movement? Do you share their views?
Yes, absolutely. But South Africa is a gloomy place, so we can say this is a milestone that the law is now in place. We can say that perhaps the glass is now half full, because the challenging of the provisions of the Act will now be specific. It will have to be surgical to say here is a piece of legislation on the table which we never had before. And if we look also in terms of the social political profile of this law, there were many hurdles that were put in place, which civil society and other people who contributed in the public participation process, they managed to erase. The issue of the cooling off of candidates, to say if you are a political party member, you cannot contest elections immediately after leaving the party, the number of signatures and many other aspects. But now, because there are these fundamental contradictions that civil society is talking about, it means when the process goes to the Constitutional Court for arbitration, we will be talking about things that must be corrected clause by clause on an existing legislation, which was never the case before.
I want to come back to the issue, Matshepiso, about you're still at this point sort of weighing up, having a look at it, studying it to see whether you are in fact going to wage more legal issues against this, or have you decided? Are you going to go the legal route with this?
Well, as I just mentioned, we have to return to the Constitutional Court, who handed down the judgment, primarily to seek clarity. And I like this suggestion that Mr. Nyembezi makes, because it's a suggestion we had raised months ago when we were beginning to raise concerns about what was emanating from Parliament's engagement in the process procedurally, but also substantively, the content that was emerging from their work, basically to suggest that a possibility is to have a reading in of the specific clauses that we cite as problematic and still unconstitutional, and that is an option. But ultimately, the goal at the moment, or the first objective, is obviously to seek clarity about whether this act, it's no longer even a bill, indeed meets the constitutional muster, and indeed we would, as we have been suggest, a reading in of the specific clauses that remain unconstitutional in our view.
Yeah. Does it concern you? Because I know that the IEC responded to this as well yesterday. That's the Independent Electoral Commission. And they were basically saying that any more legal challenges or any more wranglings around this could possibly hamper or delay the 2024 elections. This is not the first time they have said that, but obviously now with the news that it's been signed by the president and it has been brought into law, their concerns is that, you know, if anything now starts moving, the elections, the chances are they very well may not go ahead in 2024. What would your response be to that?
Well, my response has to go back even to the analogy that Mr. Nyembezi raised of a glass half full. We are not only not talking about a half glass full, but we are talking about a half a loaf. Parliament was tasked to bake a new loaf of bread, a new electoral system, really, that would give credence to citizens' right and responsibility to elect their own leaders in other ways other than through political parties, for citizens' associations to be given an opportunity at various constituency levels to have more direct representation to Parliament. Parliament chose after 33 months to produce a half a loaf of bread, which is moldy, I may say, because it raised the bar and the hoops and the obstacles that citizens' representatives have to now jump through in order to be forwarded and to represent the citizens directly. I understand where the IEC is coming from. I think it's responsible of them to work towards their 18-month, if not 2-year time frame for planning purposes, which is why they were proactive even before the president promulgated the bill to begin preparations in effect. Hence, they were ready, just as the president really announced his signing. They also announced the three ballot paper system that is going to be enforced next year, etc. So I understand their need to have a certain time frame for preparation, but at the same time, we cannot allow in a 1 or 2 generation process, because that is the gravity and the importance of this development. Probably the most important development in our constitutional democracy, really since the advent of our democratic system, because ultimately what this case is about is a test of whether ours is a constitutional rather than parliamentary democracy. It's about, as even as the judgment had indicated, it is about allowing the citizens of this nation to choose their own leaders rather than being forced to put their cross on that ballot paper next to political parties who then take it upon themselves to nominate their own proxies effectively, who are not accountable to the citizenry in every way, and whom we cannot even recall in the event that we see problems in their leadership style, for one.
So, Nkosikhulule, the New Nation movement, again, just saying that Parliament deliberately adopted its own interpretation of the Constitutional Court's judgment in tweaking the Electoral Act of '98 without giving meaningful effect to various recommendations of a more direct constituency-based system of electing members of Parliament to ensure that Parliament is accountable to the citizens. Again, I ask you, are you in agreement with these views?
Yes, I am. Remember, I wrote my doctoral thesis on this topic of opening space for independent candidates. So it looks like we are going to have a graduated system of facilitating the enjoyment of these rights for citizens to be able to stand and to be elected, and when they're elected to occupy office. A graduated system, because elections are an administered process. And so perhaps if the person on the street asks, what meaning does this have, the signing of the bill into act? It means perhaps that independent candidates, the prospective independent candidates, the prospective voters for independent candidates must begin now to prepare for the elections of 2024. Identify who you want to vote for, collect those signatures, collect those deposits, and perhaps contest the municipal by-elections so as to give profile to the people that to the process so that you get a feel. Because assuming that this matter goes to the Constitutional Court and sometime in November 2022 a judgment comes in with the reading in of the clauses that are desirable, then the prospective independent candidates and prospective voters should not be left alone. But as I say, in overall, I think it's going to be a graduated process. What we see in 2024 will be built on in the subsequent elections, and the subsequent elections, we are unlikely to get a once-off implementation of what is desirable.
Yeah, and I suppose, Matshepiso, if I can ask you, is that good enough for you? Do you feel that this is a starting point that needs to grow, or not, that this should be implemented straight away? How do you react to that?
That is indeed the poignant question. As optimistic and maybe even wise an approach as you know, a graduated approach, as Mr. Nyembezi suggests, may appear to be, the fact of the matter is it was completely deliberate. There was no need for Parliament to have interpreted the Concord judgment in the manner that they did, practically misdirecting the constituency debate and choosing to turn the judgment into a matter of just independent candidates and not addressing the other substantive element that had been raised in the judgment of creating a more direct and constituency-based system. Parliament's avoidance of the latter was completely deliberate because it is about accountability, and that is the very thing that they have proven themselves averse to entertaining. They do not want to face the citizens of this country and the electorate directly. They chose to kick the can down the road. Not only that, to then demonstrate to us their entitlement to return after these next elections to govern us again, and then constitute this panel which will do a proper job, which they could have done and should have done in the first place. They misdirected the judgment. They misinterpreted deliberately the judgment, choosing to focus only on the independent candidate element and aspect of it, which is not even what was necessarily the essence of the judgment, knowing fully well that with the additional hoops and barriers that they will then create for individual independent candidates, you misdirect the constituency debate. You don't actually give credence to what the judgment was indeed about you know, in its very essence. They could and they should have done it in the 33 months effectively that they had, but they chose not to. Obviously, because it is in their interest to not give credence and effect truly the essence and the spirit of what the judgment was about. It was always an inherent dilemma that the very people who stand to lose the most from that Constitutional Court judgment were then entrusted with the process of conceptualizing of and enacting an alternative electoral system that they themselves, you know, are likely to be the biggest losers of. So, but this is the inherent system that we have, and we cannot get away from that. Hence, it is important at this point for the citizens themselves realizing what this judgment and this enacted and promulgated act implies for them, which simply is that they still remain without the right to choose their own leaders. The very, you know, bane of our existence as citizens in this country at the moment, that we are being failed monumentally by our government, by our leaders. We have no mechanism to hold them accountable. We have no mechanism to recall them, and we have no say ultimately in who they choose as proxies to represent us in those provincial and national legislatures. And we are basically being told, you must accept this moldy half-baked bread, and we will decide when we return, which is the you know, assumption, how much further we improve on something that they should have done properly in the first place.
Indeed, and also I know, Matshepiso, Matshepiso, one of your big concerns was that the public really did not have enough time to comment on this, that was all the delays that were taking place and the public never had a say or enough of a say in this. But I don't have time for that, but I really want to wrap it up. We've got to get into the news now. Nkosikhulule, a lot was said there by Matshepiso, and I think a lot that touched the nerve of what is actually at stake here. So perhaps you want to round this up for us and give us a bit of a reaction to what was said.
Yes, this is a naked display of the balance of power politically. And if this bill is meant to bring power to the people as it is supposed to be, I think South Africa needs to prove that with more people participating in the elections. We need to have a high voter turnout, and we need to use whatever is available by way of a space to enhance our democracy, believing that at the end of the day, those who have decided on this act in the manner that it has been presented, they need to be voted out of power and replaced by a sufficient number of independent candidates and credible political party representatives.
All right. Thank you to my guests. Thanks very much for talking to us. Matshepiso Finca, the New Nation Movement spokesperson and Policy Analyst and Chairperson of the Election Monitoring Network, Nkosikhulule Nyembezi, responding to the signing of the electoral bill into law by President Cyril Ramaphosa.